Landlord-tenant, page 49 of the BARBRI outline. Part A, nature of leasehold. A leasehold is an estate in land that tenant has a present possessory interest in the leased premises, and the landlord has a future interest or reversion. Certain rights and liabilities flow from this property relationship between landlord and tenant. The three major types of leasehold estates are tenancy for years, periodic tenancies, and tenancies at will. There's a fourth category called tenancies at sufferance, which is your holdover tenant. Or any of my tenants. Tenancy for years. A, fixed period of time. A tenancy for years is one that is to continue for a fixed period of time. It may be for more or less than a year. Example, 10 days or 10 years. It may be a determinable, similar to a fee simple determinable, or on condition subsequent. The termination date of a tenancy for years is usually certain, which they didn't define. I feel like the difference between determinable an estate that automatically terminates on the happening of a stated event and goes back to the grantor, whereas the fee simple subject to condition subsequent is created when the grantor retains the power to terminate the estate of the grantee upon the happening of a specified event. Okay, so I guess it is defined, but it doesn't sound very much different. I guess it's just like one is event driven and the other, the grantor could recall on the event of something happening. It's not automatic return to the grantor. They have to re-enter. So the grantor could like forego re-entry. So where were we? The termination date of a tenancy for years is usually certain. As a result, the tenancy expires at the end of the stated period without either party giving notice to the other. Even if the date of termination is uncertain, for example, L leases the premises to T until the end of the war, most courts hold that if the parties have attempted to state some period of duration, the lease creates a tenancy for years. Creation. Tenancy for years are normally created by written leases. In most states, the statute of frauds requires that a lease creating a tenancy for years more than 1 year be memorialized in writing. In addition, most states have statutes that restrict the number of years for which a leasehold estate may be created. For example, 51 years for farm property and 99 years for urban property. When the lease term exceeds the statutory maximum, most courts hold that the lease is entirely void. Likewise, where the lease contains an option to renew for a period beyond the permitted maximum, most courts hold the entire lease void. Termination, a tenancy for years ends automatically on its termination date. Breach of covenants, and most tenancy for years leases, the landlord reserves the right to terminate if the tenant breaches any of the leasehold covenants. This reserved power is called the landlord's right of entry. Failure to pay rent. In many jurisdictions, if the tenant fails to pay the promised rent, the landlord has the right to terminate the lease, even if the absence of a reserved right of entry. Even in the absence of a reserved right of entry. Surrender. A tenancy for years also terminates upon surrender. Surrender consists of the tenant giving up his leasehold interest to the landlord and the landlord accepting. Usually the same formalities are required for the surrender of a leasehold as are necessary for its creation. Thus, writing is necessary for the surrender of a leasehold if the expired term is less than 1 year. Periodic tenancies. This is the next type of tenancy. So we're done with tenancy for years. Periodic tenancies is a tenancy that continues from year to year for successive fractions of a year. weekly or monthly until terminated by proper notice by either party. So where I said for, I meant to say or for certain or for successive fractions of a year, if not year to year. The beginning date must be certain, but the termination date is always certain until notice is given. All conditions and terms of the notice, all conditions and terms of the tenancy are carried over from one period to the next unless there is a lease provision to the contrary. Periodic tenancies do not violate the rules limiting the length of leaseholds because each party retains the power to terminate upon giving notice. Creation. Periodic tenancies can be created in three ways: by express agreement, by implication, and by operation of law. By express agreement, periodic tenancies can be created by express agreement. For example, a landlord leases a tenant from month to month. By implication, a periodic tenancy can be implied if the lease has no set termination but does provide for the payment of rent at specific periods. Example, landlord leases a tenant at a rent of $1,000 payable monthly in advance. The reservation of monthly rent will give rise to a periodic tenancy from month to month. Note, if the lease reserves an annual rent payable monthly, $12,000 per annum, payable $1,000 on the first day of every month commencing January 1, the majority view is that the periodic tenancy is from year to year. By operation of law is the other creation method. A periodic tenancy may arise even without an express or implied agreement between the parties. So first example is tenants hold over. Second is the lease is invalid. So A, tenant holds over. If a tenant for years remains in possession after the termination of his tenancy period, a landlord may elect to treat the tenant as a periodic tenant on the same terms as the original lease. Lease invalid. If a lease is invalid, for example, because of failure to satisfy the statute of frauds, and the tenant nonetheless goes into possession, the tenant's periodic payment of rent will convert what would otherwise be a tenancy at will into a periodic tenancy. The period of the tenancy coincides with the period for which the rent is paid. B, termination. Notice required. A periodic tenancy is automatically renewed from period to period until proper notice of termination is given by either party. Many jurisdictions have statutorily described the notice required to terminate a periodic tenancy. In general, the guidelines are as follows. The tenancy must end at the end of a natural lease period. For the tenancy from year to year, 6 months notice is required. For tenancies less than 1 year in duration, a full period in advance of the period in question is required by way of notice, i.e., for a month-to-month periodic tenancy, 1 full month's notice is required. In general, the notice required to terminate a periodic tenancy must be in writing and must actually be delivered to the party in question or deposited at his residence in a manner similar to that required for service of process. 3, tenancies at will. This is the next kind of leasehold, freehold, leasehold. What's the difference between a freehold and a leasehold? A leasehold. Okay, we're talking leaseholds right now. Tenancies at will. A tenancy at will is an estate in land that is terminable at will of either the landlord or the tenant. To be a tenancy at will, both the landlord and the tenant must have the right to terminate the lease at will. If the lease gives only the landlord the right to terminate at will, a similar right will generally be implied in favor of the tenant so that the lease creates a tenancy at will. Not the other way around, is what I've written in the margin. The lease is only at the will of the tenant if the lease is only at the will of the tenant for so long as the tenant wishes. Courts usually do not imply a right to terminate in favor of the landlord. Rather, most courts interpret the conveyance as creating a life estate and fee simple, either of which is terminable by the tenant. If the statute of frauds does not satisfy the conveyance as a tenancy at will. Creation. A tenancy at will generally arises from a specific understanding between the parties that either party may terminate the tenancy at any time. Note that unless the parties expressly agree to a tenancy at will, the payment of regular rent, example monthly, quarterly, will cause the court to treat a tenancy as periodic tenancy. Thus, tenancies at will are quite rare. Although a tenancy at will can also arise when the lease is for an indefinite period, one that does not satisfy the requirement for creating a tenancy for years, or when a tenant goes into possession under a lease that does not satisfy the requisite formalities, usually the statute of frauds, rent payments will usually convert it to a periodic tenancy. Termination. A tenancy at will may be terminated by either party. At common law, no notice was required to terminate a tenancy at will, but the majority of states now require that a party give the other notice of termination and a reasonable time to quit the premises. A tenancy at will also terminates by operation of law if either party dies, 2, the tenant commits waste, 3, the tenant attempts to assign his tenancy, 4, the tenant transfers his interest in the property, or 5, the landlord. 4, the landlord transfers his interest in the property, and 5, the landlord executes a term lease to a third person. Now, the fourth kind is the tenancy at sufferance. A tenancy at sufferance, sometimes called occupancy at sufferance, sometimes called holdover tenant. Actually, the holdover doctrine comes next. So this arises when the tenancy at sufferance arises when a tenant wrongfully remains in possession after the expiration of the lawful tenancy, for example, after the stipulated date for the termination of the tenancy for years, or after the landlord has exercised the power of termination. Such a tenant is a wrongdoer and is liable for rent. The tenancy at sufferance lasts only until the landlord takes steps to evict the tenant. No notice is required to end the tenancy, and authorities are divided as to whether this is even an estate land. The holdover doctrine. When a tenant continues in possession after the termination of his right to possession, the landlord has 2 choices of action. Eviction. The landlord may treat the holdover tenant as a trespasser and evict him under the unlawful detainer statute. Or B, creation of periodic tenancy. The landlord may, at his sole discretion, bind the tenant to a new periodic tenancy. Terms. The terms and conditions of the expired tenancy, for example, rents, covenants, etc., apply to the new tenancy. In commercial leases, if the original lease term was for more than 1 year, a year-to-year tenancy results from holding over. If the original term was for less than 1 year, a periodic term is determined by the manner in which rent was due and payable under the prior tenancy. In residential leases, however, most courts would rule that the tenant, a month-to-month tenant, or a week-to-week tenant, if the tenant was a roomer paying weekly rent irrespective of the term of the original lease. Example, a non-resident tenant was holding under a 6-month term tenancy with rent payable monthly. The tenant holds over and landlord binds him to a new tenancy. The new periodic tenancy is a month-to-month tenancy. That's commercial because you said non-residential. And they're paying monthly, so that's why I went to month, regardless of the 6-month term. Altered terms. If the landlord notifies the tenant before termination of the tenancy that occupancy after termination will be at an increased rent, the tenant will be held to have acquiesced to the new terms if he does not surrender. The tenant will be held to new terms even if he objects to the increased rent, provided that the rent increase is reasonable. What does not constitute holding over? A landlord cannot bind the tenant to a new tenancy under the holdover doctrine if the tenant remains in possession for only a few hours after termination of the lease or leaves a few articles of personal property on the premises. The delay is not the tenant's fault, example, because of severe illness, or lastly, it is a seasonal lease, for example, a summer cottage. So if you want to alter the terms, the landlord notifies the tenant before termination of the tenancy that occupancy after termination will be at an increased rent. But it doesn't say when. That has to be before the termination, but it doesn't say what point before the termination. Okay, again, these excuses. Tenant remains in possession for only a few hours, leaves a few articles of property. The delay is not the tenant's fault because of severe illness, or it is a seasonal lease like a summer cottage. So double rent jeopardy. Many state statutes provide that if a tenant willfully remains in possession after his term expires and after the landlord makes a written demand for possession, the landlord may double rent for the time the tenant in fact remains in possession. I didn't know that. Many states. Forcible entry states. Most states by statute prohibit forcible entry, for example, entry against the will of the possessor. Under such statutes, the landlord must not use force or self-help to remove a holdover tenant. Some states also bar the landlord from more subtle methods of regaining possession, for example, changing locks and locking out the tenant. The statutes allow the landlord to evict a tenant who has remained in possession after the right to possession has terminated. The sole issue is who has the right to possession. Questions of title must be litigated in ejectment actions rather than in eviction actions. You've got leases followed by landlord duty or tenant duties, landlord duties. And then you've got the assignments in subleases sections. That will bring us to finally condemnation of leaseholds and tort liability for landlord tenant. And this isn't finished tonight.